Muchas gracias.
Hello, how are you? Good morning to everybody. My name is Andrea Pochak. Please be sure that you can use the translator because I will be speaking in Spanish. Okay. Buenos días a todos y todas. Mi nombre es Andrea Pochak. Soy la vicepresidenta de la Comisión Interamericana y voy a estar coordinando esta audiencia número 13 en el marco de nuestro 193 periodo de sesiones. El objetivo de esta audiencia es conversar sobre la situación de los derechos humanos de migrantes, refugiados y solicitantes de asilo en Estados Unidos. Les agradecemos mucho a las organizaciones que han solicitado esta audiencia. Voy a nombrarlas al otro lado: Americans for Immigrant Justice, Amnistía Internacional, Centro de Derechos Humanos y Derecho Constitucional, Proyecto de Derechos de los Inmigrantes y Refugiados de Florence, Haitian Bridge Alliance, Hope Border Institute, Human Rights First, Instituto para las Mujeres en la Migración, Immigrant Defenders Law Center, International Refugees Assistance Project, Las Américas Immigrant Advocacy Center, Raíces and Refugees International. También queremos agradecer especialmente la participación de las representantes del Estado que están aquí en la audiencia, la señora Lily Calafell, representante alterna de la Misión Permanente de los Estados Unidos ante la OEA, y Sarah Hunter, asesora jurídica del Departamento de Estado, Oficina del Asesor Jurídico de Derechos Humanos y Refugiados. Muchas gracias a las organizaciones y muchas gracias a las representantes del Estado por estar aquí presentes. También vamos a contar con la participación de Matthew Gillett, que es el vicepresidente del Grupo de Trabajo de Detenciones Arbitrarias de Naciones Unidas. Thank you, Matthew. Muchas gracias, Matthew, por tu participación. Hemos recibido solicitudes de distintos mecanismos de Naciones Unidas para participar de esta audiencia. Por razones de tiempo y de reglas, contamos con un solo mecanismo. Esta audiencia se enmarca en un momento en donde la Comisión Interamericana está advirtiendo serios retrocesos y desafíos en materia de derechos humanos en toda la región, de manera que es una oportunidad para reforzar nuestro compromiso con la promoción y protección de derechos humanos y reforzar la importancia que tienen estas audiencias públicas para visibilizar situaciones de preocupación en materia de derechos humanos. Es una audiencia que pretende ser accesible, de manera que les pedimos que cuando usen la palabra se presenten, digan su nombre, su cargo, su institución, para que las personas con discapacidad visual puedan seguir la audiencia. Y es una audiencia que también tiene subtítulos para que las personas que necesitan seguir la audiencia de esa manera lo puedan hacer con distintos tamaños. Como verán, es una audiencia con interpretación simultánea, de modo que les pedimos que hablen despacio para que las personas intérpretes puedan hacer su trabajo. Estoy acompañada por la comisionada Roberta Clark, que es relatora para Estados Unidos, el comisionado Arif Vulcan, que es el segundo vicepresidente, y la comisionada Gloria Monique Denis. También están presentes la secretaria ejecutiva, Tania Renault, la secretaria ejecutiva adjunta para monitoreo, María Claudia Pulido, y veo también al relator especial de Derechos Económicos, Sociales, Culturales y Ambientales, Javier Palum. El objetivo entonces es escuchar primero a las organizaciones y luego escuchar al Estado. Vamos a distribuir el tiempo de la siguiente manera. Primero va a tener 20 minutos la sociedad civil para hacer su presentación, luego va a tener 20 minutos el Estado, luego va a tener 7 minutos el experto de Naciones Unidas y luego retomaremos la palabra desde la Comisión Interamericana. Van a ver un reloj, un cronómetro, y les pedimos que lo tengan en cuenta para poder aprovechar bien el tiempo disponible y no tener que interrumpirlos. Con esta introducción, entonces, le paso la palabra a la sociedad civil por 20 minutos.
Morning and buenos dias, esteemed commissioners. My name is Yannick Gill, Senior Counsel with Human Rights First.
Human Rights First, with over a dozen nonprofit organizations, would like to thank you for your attention around the egregious human rights abuses we have seen committed against the migrant community, asylum seekers, and refugees at the hands of the United States government. Since our submission to the Inter-American Commission on Human Rights in April, there has been further escalation, not just surrounding arbitrary detention, but also enforced disappearances. We welcome the analysis and oversight of this admirable body and hope to collaborate with the United Nations Working Group on enforced and involuntary disappearances in future hearings, given the breadth of the illegality of the government's actions. We remain concerned that the deportations and related detentions are not consistent with international law, including the prohibitions on unlawful or arbitrary expulsion, freedom from arbitrary detention, the right to due process in the expulsion of immigrants and asylum seekers, and the obligation of non-refoulement. Today, you will hear from experts detailing the recorded stories of vile abuses of asylum seekers and migrants from U.S. officials over the last 6 months. But do note, without international intervention, this will only worsen. Just this month, the United States has signed into law an unprecedented bill which will establish more prisons where families, including infants, can be incarcerated with little to no oversight. This will lead to preventable deaths, put children at risk, and undermine our democracy. We pray that today's hearing is only the beginning of international oversight of these gross human rights violations of both U.S. and international law. Thank you.
Good morning. Thank you so much for the opportunity of this hearing. My name is Rebecca Gendelman, and I'm a researcher with Human Rights First. I'd like to discuss the U.S. government's transfers of migrants in its custody to third countries, countries to which they have not been ordered removed through any legal process, and of which they are not nationals, where they are then detained, face potential refoulement to home countries, or suffer other human rights abuses. Over the past 6 months, we have witnessed such transfers at all stages of the immigration process, affecting people who are in the middle of their immigration proceedings, as my colleague from Immigration Defenders will describe in a moment, people who have just arrived to seek asylum and are expelled without even a screening on their protection claim, people who are already granted humanitarian protection in the United States, and people with existing removal orders. These unlawful transfers have been carried out pursuant to often undisclosed agreements with the third countries. They violate human rights obligations and in many cases have constituted enforced disappearances. The government has also carried out some of these transfers in blatant violation of U.S. court orders. Human Rights First and Refugees International have conducted research on the government's recent transfers of asylum seekers, including families with young children, to Costa Rica and Panama without a screening on their asylum claim. People reported to us that while in U.S. custody, they were often denied the ability to call their family or an attorney, suffered other abuses, and then were transferred by U.S. officials to Costa Rica or Panama, where they were detained in remote locations. Some were transferred there without being told where they were going, or without an opportunity to tell their families who were desperately searching for them. Some have now been left indefinitely separated from their spouses, children, and other relatives in the United States who have pending asylum cases. The Trump administration carried out many of these transfers pursuant to a January 2025 presidential proclamation that suspends access to asylum for anyone arriving at the U.S.-Mexico border, in blatant violation of U.S. and international refugee law. These cases are included in a joint report by Human Rights First and Refugees International titled, "This is an Order from Trump: Abuse, Expulsions, and Refoulement of People Seeking Asylum," which has been provided in the supporting documents. The U.S. government has also removed and is seeking to remove migrants with final orders of removal to third countries without notice or an opportunity to raise any fears of persecution or torture in these unexpected destinations. 8 men transferred to South Sudan on the 4th of July in violation of a U.S. court order are still detained there incommunicado 3 weeks later. Thank you very much for your time.
Good morning, buenos dias. My name is Margaret Cargioli. I am Directing Attorney of Policy and Advocacy at Immigrant Defenders Law Center. Thank you for this opportunity. Gracias por esta oportunidad. On March 15, 2025, over 250 Venezuelan immigrant men were disappeared by the Trump administration to the Center for Terrorism Confinement, CICOT, in El Salvador for over 4 months under the unlawful use of the Alien Enemies Act. These men had no direct contact with their family or attorneys during all of that time. In April 2025, CBS News 60 Minutes, a report found that of 238 men, 75% had no criminal record. Immigrant Defenders Law Center represents 8 men in their immigration proceedings. They have no convictions and were seemingly stereotyped by the US government as having gang affiliation with Tren de Aragua because of benign tattoos, including a rosary. One of our clients, Andri Hernandez Romero, is a gay asylum seeker with no gang ties or convictions, who was held in Otay Mesa Detention Center, where he was sexually abused. He was suspected of affiliation with Tren de Aragua for crown tattoos with the words mom and dad that he chose to honor the Three Kings Day Catholic holiday. On June 4th, 2025, a US federal court found that Andri and the other men who were sent to CICOT had their due process rights violated, and the judge ordered that the US propose a process that will provide the men with those due process rights that they were denied. While they were in CICOT, each day that passed until they were released from the human rights violating prison, they were filled with unspeakable trauma, and it was traumatic for their families. Then, without any choice in the matter, these men were used as political pawns between 3 authoritarian governments and sent to Venezuela, the same place that many of them had fled due to persecution. I am disheartened to share in the initial conversations with our clients who were recently released from CICOT and via interviews they've done with media in Venezuela since their release, that they have confirmed severe psychological abuse, physical abuse, and in Andri's case, continued sexual abuse while in CICOT. Their dream of safety became a 4-month nightmare in the moment the Trump administration denied them due process. It left them emotionally, physically, and mentally damaged despite the relief of release from CICOT and reunification with family. Their story is far from over, and we are nowhere near justice for these men. We are gravely concerned about continued persecution of people that fled Venezuela due to persecution. We have long said that Andri's case is like a canary in a coal mine, as we face the possibility of more people experiencing the same fate as these 252 men because of Trump's policies of denying due process and constitutional protections to asylum seekers, immigrants, migrants, and refugees. This is why the Trump administration must be held accountable for the pain and irreparable harm his policies cause and continue to cause every day. We must continue to build up the momentum of public pressure, as it will take all of us, the entire world, to protect the dignity of asylum seekers, migrants, refugees, and immigrants. Thank you.
Good morning. I'm Jesus de la Torre, and I serve as a contractor at the Hope Border Institute, a strategy center for faith leaders pursuing justice at the US-Mexico border. I will discuss systemic denial of access to asylum at the border and concerns over land removals, with evidence collected during monitoring with border organizations and Catholic shelters. On January 20th, 2025, President Donald Trump signed Securing Our Borders, an executive order that, among other things, mandated the end of CP1. and issued a proclamation guaranteeing the state's protection against invasion, which suspended access to the US to migrants engaged in the invasion, quote-unquote, across the southern border and prohibited them from seeking asylum or other legal protections. Since then, and despite ongoing domestic litigation, there hasn't been any meaningful and accessible way to seek asylum and international protection at the US-Mexico border. About 30,000 already scheduled CEP1 appointments were canceled. People with CEP1 appointments for January 20th were either detained at ports of entry, with a group of at least 25 individuals detained in Arizona, or instructed to walk back to Mexico. Asylum seekers at and between ports of entry are routinely denied access to asylum. That includes Enrique, an internally displaced Mexican national to whom Office of Field Operations agents asserted there is no asylum anymore. Testimonies of removed individuals also confirm that Border Patrol agents tell asylum seekers that asylum is over. Upon individual removals through the land border, Mexican and third country nationals alike often face abuse and do not receive their belongings and any documentation of their removal. For example, ICE put Clara, a Venezuelan woman 8 months pregnant, twice on a plane before removing her through the land border in El Paso, severely endangering her and her baby's life. She received no documentation of her removal. In Mexico, stranded asylum seekers face immediate dangers to their physical, psychological, and emotional well-being. Asylum seekers deserve dignity and safety, and close to their dreams and pain, we urge the US to abide by its obligation to them and the Commission to use all means available to protect them. Thank you.
I'm Eric Crew, staff attorney with the Haitian Bridge Alliance, and I'm appearing alongside our executive director, Gerline Joseph. And at the Haitian Bridge Alliance, we're appearing today as a witness to the profound human suffering caused by this campaign of mass immigration arrests in the United States. We're here to tell you the images you see, the stories you hear, they're real. We have stood outside immigration courts and watched masked agents arrest people who came seeking justice, people trying to comply with the US's immigration law, only to be taken away without warning. We've received desperate calls from families whose loved ones were snatched during routine check-ins and disappeared, to remote prisons across the country, others perhaps to Guantanamo Bay, others deported back to danger in the state from which they fled, and still others deported to third countries they've never known. This administration's mass arrest and detention campaign is designed to create complete panic, terror, chaos, and trauma within our communities. Children are afraid to go to school. Parents are unable to leave their homes to go to work or go to the hospital. Families and counsel must go through a maze to locate someone if they have been disappeared. The level of terror, trauma, and fear that we are experiencing cannot be explained. One thing we see clearly on the ground, though, is that these mass arrests are not about legality or public safety, which makes it all the more terrifying. No, we see the reality that this campaign is built on one of the largest acts of mass delegalization by a state in modern history. Haitian Bridge Alliance knows well that at least over 1 million individuals that have followed lawful pathways have had their status, their lawful status, vacated, canceled, or revoked en masse over the last 7 months. These are people who did everything the US asked of them, and they are now among the first targeted. This campaign is an extreme act of an extreme administration, yes, but it also should be seen as the act of a nation whose extreme immigration system and migration policy have been built around anti-Black, anti-brown, and anti-other animus, and based in a prevention through deterrence strategy that targets people who should be protected by the International Convention on the Elimination of All Forms of Racial Discrimination. Civil society like ours are exhausting our domestic legal remedies, but the rule of law itself is under attack, and the US continues to refuse to align its domestic law with international human rights laws, and it avoids compliance with treaties and courts that demand accountability with respect to its ongoing violations. But we're here to use every mechanism available to us. And so we ask you, the Commission, to use every mechanism available to you to demand transparency, dignity, and justice for the people we serve. Thank you.
Good morning. My name is Taylor Kohler, and I'm a staff attorney with the Center for Human Rights and Constitutional Law. Our legal nonprofit serves as class co-counsel for Flores v. Bondi, the federal court case through which the Flores Settlement Agreement is enforced. The Flores Settlement is a landmark court order that protects immigrant children from prolonged detention and inhumane conditions in federal custody. For nearly 30 years, it has set basic care standards, limited detention time, and allowed independent oversight. But today, the U.S. government is working to end protections for immigrant children. In May, the U.S. Department of Justice filed a motion to terminate the settlement outright. And Congress has since enacted legislation through the 2025 Budget Reconciliation Bill that allocates significant funding to the expansion of family detention. Flores Class Counsel has documented and filed with the overseeing federal court declarations describing worsening conditions and grave human rights abuses affecting children and families. As a result of this administration's policies, immigrant children are languishing in immigration prisons for extended periods, sometimes months, under conditions that plainly violate their human rights. Some of these children are ripped from their homes in the U.S. and miss high school exams, first dates, or family milestones, weddings, birthdays, and graduations while in prison. Others are detained while crossing the border to seek asylum. These children are imprisoned in unsafe, unsanitary facilities, often separated from their families during their already traumatizing detention, and treated with cruelty and indifference, conditions no child should ever be forced to endure. The declarations documenting these harms have been shared with the IACHR, and I'll leave you with the words of a 16-year-old detained child. I heard one officer say about us, "They smell like shit." And another officer responded, "They are shit. They treat us like we are not human beings." This is not just a failure of law, it is a failure of humanity. Thank you.
Good morning and thanks to the commission. My name is Javier Hidalgo. I am a legal director here at Raíces. I oversee our team that works with families who are detained in ICE detention. My colleague just mentioned the Flores settlement and the protections. And we're in a moment right now where the government's actively trying to do away with those protections, right? And I think what we're actually seeing on the ground is the government's actually acting as if those protections are already gone, right? Any of the protections that are enumerated there, the amount of time that families can or children can be in these unlicensed facilities and these harmful conditions, government currently is blowing past those dates, right? We're seeing kids detained in these ICE detention centers weeks and months past that. These are conditions that are not appropriate for children at any time. That's well documented. That's well established. That's not new. What's new now is that any semblance of attempts to hold to the norms and laws that protect these children are gone. They're out the door, right? We're seeing any time that we try to alert ICE that they're in violation of these protections, those calls go largely ignored or disregarded. More alarmingly, what we're seeing in family detention and ICE custody with children in ICE custody is that the harmful new policies of the government are playing out even more egregiously with children, right? Family separation, we're seeing different versions of that happen now. Families that are arrested in often very harmful ways at immigration court hearings are showing up in these detention centers. And we're seeing these things happen in really alarming numbers and alarming ways. I would hope that this commission can urge the government to come back to abiding by the norms that are in place and protect the children that are in these conditions that are, again, well established, should not ever be where a child is held, right? But that's what this is. Carceral settings that are designed to detain adults who are criminals. And what we're seeing is children and families who are in no way criminals detained in harmful conditions. And we're hoping that something can change. Thank you.
¿Han concluido la presentación las organizaciones? ¿Han concluido? Voy a pasar entonces la palabra al ilustre Estado de Estados Unidos por 20 minutos.
Thank you. Commissioners, colleagues, my name is Lily Calafell, and I am the acting political counselor with the U.S. mission to the Organization of American States. I'm gathered here today with my colleague Sarah Hunter from the Legal Advisor's Office to represent our government in this hearing. Thank you all for being here. The United States strongly supports the work of the Inter-American Commission on Human Rights, and we regard the institution as vital to the promotion and protection of human rights in the Western Hemisphere. We are pleased that for the first time in over a decade, the OAS General Assembly elected a U.S. nominee, Rosa Maria Paya, to serve on the commission. Her experience as a human rights defender will bring a valuable perspective to this work. While we acknowledge the importance of the issues raised, we note at the outset that many of these matters are in active litigation in U.S. courts. We are here as part of a thematic hearing under Article 66 of the Commission's Rules of Procedure and not a petition-based hearing under Article 64. As such, we will not discuss any particular situation or case. To do so would not be appropriate in this forum, while the cases remain in litigation in our courts. Further, given our long-standing position of not commenting on active legal proceedings, we will not answer questions about specific cases presently in domestic litigation, but rather would direct you to the U.S. government's public filings in those cases. We continue to stress that the Commission seems to have made it standard practice to insert itself into ongoing domestic political discussions through the mechanism of a thematic hearing. The subjects on which the Commission convenes these hearings are often complex, fast-changing, the subject of significant domestic litigation or congressional consideration, and of great political and diplomatic sensitivity. This makes it very difficult for the United States to meaningfully engage with the Commission and reduces the value of the Commission's involvement. We continue to note that the Commission has numerous petition-based cases that are procedurally awaiting a decision that may benefit from a hearing. And yet in this period of sessions, the Commission has scheduled only one petition-based hearing. We urge the Commission to increase hearings on petition-based matters that are procedurally ready for decision and to continue issuing reports on admissibility and merits at a pace that can decrease its numbers of pending cases. Turning now to why we have convened here today. Illegal immigration and insecure borders are among the most pressing issues in the region, and their effects are felt everywhere, including acutely in the United States. As President Trump's executive orders make clear, our government is deeply and fully committed to combating illegal immigration and enforcing our domestic laws, to defeating the transnational criminal and paramilitary organizations that violate our sovereignty, kill our citizens, and destabilize our hemisphere, and to securing our borders. As the Commission knows, our Constitution and domestic laws make it clear that the United States has the sovereign right to control admission or entry into our territory and to regulate the admission and expulsion of alien foreign nationals. This principle has long been recognized as a fundamental attribute of state sovereignty under international law. The American Declaration of the Rights and Duties of Man itself recognizes this principle in Article 28, which makes clear that while individuals have a right to seek asylum, they must do so in accordance with the laws of each country and with international agreements. Moreover, Article 33 notes that it is the duty of every person to obey the law and other legitimate commands of the authorities of his country and those of the country in which he may be. The Commission must not forget or elide these duties. Actions to remove individuals from the United States who fail to follow our laws, including the laws governing aliens' entry into our nation and their conduct in our land, are fully consistent with our commitments under the American Declaration and obligations under international treaties that our Congress has given its advice and consent to, and the President has ratified. The United States adheres to our applicable legal obligations by, for example, conducting screening procedures for those who may be eligible for asylum or other protections. I now turn to the matter of third country removals. The hearing highlights the removal of individuals to third countries over the past several months. These removals were coordinated with the receiving countries because those deported did not have a valid legal basis to remain in the US. Enforcing US immigration laws and policies, including deportation of persons with no legal basis to remain in the United States, is critical to upholding the rule of law, securing our sovereignty, and protecting American citizens and others who lawfully reside in our country from violence, crime, exploitation, and intimidation. We're engaging with our neighbors across the Americas to end border insecurity and illegal migration. Addressing the crisis of illegal immigration is a regional imperative and challenge, and we encourage our partners to take all necessary steps to enhance the security of their own borders, accept their repatriated nationals swiftly and without impediment, implement visa requirements, and foster the conditions for people to stay and build a safe and prosperous future in their own homelands. When foreign nationals ordered removed from the United States cannot be repatriated to their home countries, such as when they have been lawfully found entitled to protections under the Convention Against Torture, the United States can and often has engaged foreign partners to identify alternate safe locations to which they can be removed. US law and policy provides that we can and do remove those who have had their claims adjudicated and have final orders of removal. With regard to those removed to states such as Panama, Costa Rica, and El Salvador, we have confidence that these nations are committed to following their own laws and their obligations under international law, including their obligations under international human rights law. To the extent that allegations of human rights abuses arise in these states after they've left US custody, it is those states that bear responsibility. Given the themes under discussion today, we are taking the opportunity to use this hearing to provide a response to the request sent by the Commission to the United States on May 12, 2025, under Article 18 of its statute. In that letter, the Commission requested information on certain individuals who were removed from the US to El Salvador. We regret that we were unable to provide a response sooner. On January 20th, 2025, President Trump issued an executive order entitled Designating Cartels and Other Organizations as Foreign Terrorist Organizations and Specially Designated Global Terrorists. This executive order states that international cartels constitute a national security threat beyond that posed by traditional organized crime, and notes the campaign of violence and terror that these entities have spread throughout the region. Consistent with this executive order, the Secretary of State designated the Venezuelan gang Tren de Aragua as a foreign terrorist organization and a specially designated global terrorist. As further detailed in the department's February 20th press release, Tren de Aragua is a transnational organization that originated in Venezuela with cells in Colombia, Peru, and Chile, with further reports of sporadic presence in Ecuador, Bolivia, and Brazil. This brutal criminal group has conducted kidnappings, extorted businesses, bribed public officials, authorized its members to attack and kill US law enforcement, and assassinated a Venezuelan opposition figure. As a result of these designations, all property and interest in property of those designated that are in the United States or that are in possession or control of a U.S. person are blocked, and U.S. persons are generally prohibited from engaging in transactions with them. On March 15th, the United States deported to El Salvador 238 Venezuelan nationals associated with Tren de Aragua. At the time, Nicolás Maduro was refusing, for political reasons, to accept the return of Venezuelan nationals to their home country. Upon their arrival, El Salvador decided to house these individuals in its terrorism confinement center, known as CCOT, in a part of the prison that is separated from the general prison population. An additional 14 Tren de Aragua affiliated individuals were deported to El Salvador in the weeks that followed. El Salvador made the decision to house these individuals in CCOT as well. The United States deported these Venezuelan nationals to El Salvador pursuant to a non-binding arrangement between the U.S. and El Salvador that was reported to the U.S. Congress in compliance with a federal statute known as the Case Zablocki Act. The arrangement is publicly available on the State Department's Case Act website. In that arrangement, El Salvador committed to accept approximately 300 Tren de Aragua affiliated individuals from the U.S. and gave its assurances that it would comply with its obligations under Salvadoran and international law, including the Convention Against Torture, in its reception of these individuals. Following the deportation of these 252 Tren de Aragua affiliated individuals from the U.S. to El Salvador, Maduro resumed accepting Venezuelan deportees from the U.S. Thousands of Venezuelan nationals with no authorization to remain in the U.S. have been repatriated directly from the U.S. to Venezuela since that time. During the time these 252 Venezuelan nationals were confined in CCOT, a U.S. federal court held that they were not within the custody or control of the U.S. This holding reflected the shared understanding of the United States and El Salvador about how El Salvador has sole custody and control over them. Accordingly, any questions the Commission or our civil society colleagues may have regarding the detention and treatment of those in CCOT are properly directed to El Salvador. In April, President Bukele proposed to Nicolás Maduro a humanitarian agreement involving the repatriation of the Tren de Aragua members to Venezuela if the Maduro regime would release a large number of Venezuelan political prisoners. While the Maduro regime publicly rejected that proposal, President Bukele remained interested in a humanitarian solution. Several weeks later, the United States resolved to use its diplomatic good offices to help the two sides achieve the humanitarian solution President Bukele had offered. After weeks of discussions, a deal came to fruition on July 18th when El Salvador decided to release the 252 Venezuelans that were in its custody, and the Maduro regime released 10 unjustly and wrongfully detained Americans, along with dozens of Venezuelan political prisoners. While the United States urged both President Bukele and the Maduro regime to make the decisions that resulted in the movements that occurred on July 18th, the decisions were theirs to make. To ensure the greatest possible compliance with orders by U.S. courts, the United States obtained assurances from the Maduro regime that, first, if a court requires the appearance of one of the former CCOT detainees, and the United States is prepared to facilitate the person's travel to the United States, and the person wants to travel for this purpose, then the Maduro regime will not impose obstacles to the person's travel. On July 18th, a U.S. aircraft transported the released Americans to El Salvador, and 2 Venezuelan aircraft transported the released Venezuelans to Venezuela. Following the simultaneous departure of these aircraft, President Bukele tweeted, and I quote, "Today we have handed over all the Venezuelan nationals detained in our country, accused of being part of the criminal organization Tren de Aragua," end quote. He characterized this resolution as the consummation of his original offer, and I quote, "As was offered to the Venezuelan regime back in April, we carried out this exchange in return for a considerable number of Venezuelan political prisoners, people that regime had kept in its prisons for years, as well as the American citizens it was holding as hostages, end quote. He praised the, quote, tireless efforts of many officials from both the United States and El Salvador, end quote. At a ceremony honoring the freed Americans later that day, President Bukele explained why the successful operation mattered to him, and I quote, "We've been in these negotiations trying to set you, all of you, free, but also 80 political prisoners from Venezuela. For us, the reward is the happiness of the fulfilled duty that we've been able to free 80 Venezuelans and 10 American citizens who are now going home," end quote. The United States is grateful to President Bukele for his leadership in achieving this humanitarian solution. Many former detainees have since been reunited with their families in their home countries. As far as we're aware, the 252 Venezuelans formerly in El Salvador are not in detention in Venezuela. But any decision to detain them would, of course, be the sole responsibility of the Maduro regime. I'll now turn to the topic of asylum at the US-Mexico border. To protect our citizens, our sovereignty, and our Constitution, there have been sweeping changes to US border policy in the last several months. Under the Trump administration, the United States is vigorously protecting our border, enforcing our laws as they are written, and removing illegal aliens. Our diplomatic engagement with Mexico to strengthen control of our shared border and arrange the deportation of illegal aliens is critical to ending illegal immigration and keeping Americans safe. To that end, we are working with government leaders to identify and dismantle the cartels and paramilitary groups that run alien smuggling and human trafficking networks by identifying, apprehending, prosecuting, and convicting smugglers and traffickers, enhanced land and maritime border security, and protecting victims of human trafficking. In addition, halting illegal immigration helps stop the flow of illicit narcotics and other drugs from entering the United States. Actions to curb such illegal actions serve only to increase security for both Mexico and the United States and increases economic prosperity. Increasing vigilance at the US-Mexico border additionally discourages those without a lawful basis for entering the United States from making the dangerous and often deadly trek through the Darien, deserts, or maritime routes. Effective January 20th, 2025, the CBP-1 system that allowed aliens to make appointments to seek admission at US border crossings is no longer available, and existing appointments have been canceled. This action does not violate international law. On March 10th, 2025, US Customs and Border Protection announced a new public-facing mobile application, CBP Home. The application has a feature, Intent to Depart, which offers illegal aliens or those aliens whose parole has been revoked an orderly and defined voluntary process to notify the US government of their intent to depart the United States. While removed aliens may assert claims regarding the alleged lack of legal and social protection in countries, our legal obligations generally do not extend to the territory of other countries, and concerns about other countries supposedly failing to live up to their obligations should be directed to those countries. We will answer questions as we are able, but I would underscore my previous remark that we are unable to comment on matters in active litigation. As I also noted, questions regarding the treatment of persons under the custody and control of other countries should be directed to those countries. Thank you.
Muchas gracias a la representación de Estados Unidos. Voy a pasarle la palabra al experto de Naciones Unidas, el vicepresidente del Grupo de Trabajo de Detenciones Arbitrarias, señor Gillett. Tiene usted la palabra.
Gracias. Thank you, Commissioner. Thank you to everybody present and good morning. As mentioned, my name is Matthew Gillett and I'm the former chair and rapporteur of the Working Group on Arbitrary Detention and the current vice chair, also a member of the Platform of Independent Experts on Refugee Rights, which is a new initiative amongst UN special procedures and other international human rights and regional human rights bodies. I do have to say at the outset that I'm here to provide an informal, unsworn oral briefing in this public hearing of the Inter-American Commission. This is provided on a strictly voluntary basis without prejudice to the privileges and immunities of the United Nations, including its officials and experts on mission, and nothing should be considered as a waiver of any of those privileges or immunities. Commissioners and everybody present, the situation of asylum seekers, migrants, and refugees presents multiple challenges to the applicable human rights frameworks across several intersecting ways. One of the most pressing, and the one on which I'm most qualified to speak, is that of detention. This is an area that the working group deals with on a daily basis. And I should emphasize at the outset that, as with all of our activities, we do endeavor to uphold the highest standards of objectivity, impartiality, and legal and factual rigor. To this end, it's extremely important that we do receive submissions, of course, from civil society and representatives of detained people, but also from governments that engage with our processes, as otherwise we're left to decide matters based on an incomplete record. On the legal and normative front, I should highlight at the outset that seeking asylum is not a crime in and of itself, and the working group has consistently maintained this and emphasized that, on the contrary, seeking asylum is a universal human right under Article 14 of the Universal Declaration and recognized in the Refugee Convention and the 1967 Protocol. States, of course, have a right to enforce their borders, but they must do so in accordance with applicable human rights standards. If they do not adhere to those standards and they detain people, this may amount to arbitrary detention. Arbitrary detention itself is wrong in all circumstances and is recognized widely as a prohibition under customary international law. And one of the reasons, in addition to being wrong in and of itself, that it creates concerns is that it can lead to further violations, extrajudicial killings, torture, cruel, inhumane treatment, and enforced disappearances, amongst various mistreatment. We've addressed multiple cases of migrants and asylum seekers who've been detained, and we actually have an explicit category under our methods of work. This is category 4, which applies when asylum seekers, migrants, or refugees are subjected to prolonged administrative custody without the possibility of judicial review or remedy. We've also issued in 2017 a revised deliberation number 5 on the deprivation of liberty of migrants. And I'll highlight from that paragraph 3, which notes that the right to personal liberty is fundamental and extends to all persons at all times and circumstances, including migrants and asylum seekers, irrespective of their citizenship, nationality, or migratory status. So that's the background presumption of at the normative level. With that, there are, of course, exceptions, but any form of administrative detention or custody in the context of migration must be applied as an exceptional measure of last resort for the shortest period possible, and only if justified for a legitimate purpose, such as documenting entry and regarding claims or initial verification of identity when in doubt. There are several key issues that are arising in a general sense in this realm. So firstly, the issue of alternatives to detention. And on this, we would highlight that alternatives to detention should always be sought as a first step. These may include regular reporting at intervals to the authorities, community-based solutions, bail or other securities if strictly necessary, or staying in open centers or designated places. We also have the issue that frequently comes before us of procedural protections. And this is particularly important in the context of migration-related legal proceedings. In this context, if detention is at issue, we reinforce that this must be ordered and approved by a judge or other independent judicial authority as a safety check and balance on the exercise of power by the executive. Anyone detained in the course of migration proceedings must be brought promptly before a judicial authority and should have access to automatic, regular, and periodic reviews of their detention to ensure that it remains necessary, proportional, lawful, and non-arbitrary. Very importantly, human rights law lays down the requirement that detention should be assessed on an individual basis and not simply on a category basis relating to a person's migration status. The detention, as stated before, must comply with the principles of proportionality and not be a simply automatic or mandatory imposed measure. A third issue I want to highlight is that of de facto detention. And on this, we would reiterate that even where persons are held at informal locations, non-traditional centers, this will be a matter that can come within our mandate and before us. So we've set out in our revised fact sheet number 26, our mandate covers deprivation of liberty in all its forms, and we frequently deal with cases outside the regular administrative or criminal justice systems. A final substantive point is on children in the context of migration and asylum seeking. And here we've emphasized that deprivation of liberty of children in this context, including unaccompanied or separated children, should be prohibited and not countenanced in any circumstances. There's further guidance that can be found on all of these topics in a very comprehensive position paper of UNHCR, and this is titled Unlocking Rights Towards Ending Immigration Detention for Asylum Seekers and Refugees. To address these issues, we will continue to cooperate with other entities such as the peer. So in conclusion, we will continue to work on these matters respecting the liberty and physical integrity of all persons and do so independently with neither fear nor favor. Thank you very much for your attention.
Muchas gracias y lamento el poco tiempo que tenemos para las intervenciones. Muchas gracias por sus aportes. Es el momento ahora de que la Comisión Interamericana pueda tomar la palabra y hacer algunas preguntas a las organizaciones y al Estado. Quisiera simplemente comenzar, antes de darle la palabra a la relatora de país, la comisionada Clark, antes de darle la palabra en mi carácter de vicepresidenta de la Comisión, quisiera hacer alguna aclaración sobre la audiencia para que luego podamos enfocarnos en el tema de la audiencia, que es la situación de las personas migrantes y refugiadas. Quisiera aclarar, primero agradecer a la representación de Estados Unidos por el apoyo explícito dado a la Comisión Interamericana y lo valoramos mucho, pero queremos aclarar que las audiencias que la Comisión Interamericana otorga responde a las solicitudes de audiencias que recibe y cada periodo de audiencias hemos recibido más de 100 solicitudes, 120, 130, 150 y debemos elegir entre esas audiencias solicitadas. Luego aclarar que, por supuesto, priorizamos nuestro sistema de casos y peticiones y por eso cada vez más son más los casos que la Comisión Interamericana viene resolviendo año a año, lo podrán ver en nuestras estadísticas. Si no otorgamos más audiencias de casos en el periodo de sesiones es o porque los casos no están procesalmente listos para dar audiencias o porque las audiencias no son necesarias para resolver los casos. De todas maneras, los comisionados y las comisionadas durante todo el año y en el periodo de sesiones participamos en reuniones de trabajo sobre medidas cautelares, sobre soluciones amistosas, sobre casos en transición, de manera que priorizamos, entre otras cosas, gracias al apoyo financiero que recibimos de Estados Unidos, el sistema de casos y peticiones para dar respuesta a nuestra demora histórica. Finalmente, el sistema de audiencias es una audiencia para analizar la situación general, como estamos viendo en este caso, y si se tratan en algunos casos es a título ejemplificativo. Esa es la práctica que la Comisión tiene, recibir los casos a título ejemplificativo para poder ilustrar una situación general. Con esta aclaración sobre nuestras facultades y sobre nuestra herramienta de medidas cautelares, quiero pasarle la palabra en primer lugar a la relatora de país, Roberta Clark.
Thank you very much, Vice President Pochak, and good morning to everyone, representatives of the civil society who requested this hearing, and of course, greetings to the representatives of the state. I want to start off by reiterating what the Commission has reiterated and repeated in relation to matters concerning human mobility. First of all, the Commission recognizes that states, all states, have the authority and indeed the duty to set their migration policies and to determine who may enter, exit, and remain in their territory, and to do so according to international principles. We say that these international principles include, very importantly, the human rights principles. So these laws and policies and practices on migration must respect and ensure the human rights of persons in human mobility. And in this case, what are these rights, or where are they embodied? They're embodied, of course, in domestic legislation and constitutional arrangements, fundamental rights and freedoms at the level of the state. But also, I wish to remind everyone that the rights, the founding document, the founding human rights document of the Organization of American States is the American Declaration on the Rights and Duties of, I always pause here because I hate to say man. So we say on the rights and duties of people. I'm renaming the declaration, but it's there. And inside of that declaration, which is dated 1948, and my predecessor on the commission, former Commissioner Margaret May Macaulay, would always remind us that this American Declaration predates the Universal Declaration. And in that declaration, under Article 27 is the right to asylum. Under Article 26, the right to due process of law. Under 25, right of protection from arbitrary arrest. Of course, number one is always the right to life and personal integrity. And very importantly, right to life, liberty, and personal security. And very importantly, in relation to the perceptions shared by civil society organizations here, there's a right to equality before the law. So we are, in this hearing and in relation to the United States here, we are really paying close attention to the American Declaration of Rights and Duties of People, which the United States has very much been a historic champion of this declaration, as setting the tone of human rights and also the tone of international assistance and cooperation among member states of the OAS. So I want to say that this commission, we have heard quite a lot from civil society organizations that have been monitoring state policies and practices over the course of this year. And of course, before this year, this commission has always been receiving information from human rights defenders who are concerned about how migrants, asylum seekers, and refugees are being treated. But we have listened very carefully to civil society organizations speaking about the denial of access to asylum, of refoulement, of arbitrary detentions and abuses in government custody, and of disappearances. Migrants, refugees, asylum seekers who are taken into detention without necessarily information shared with their families and without their families knowing their whereabouts for a bit of time. So I wanted to start by asking, so all of that, of course, is of great concern, and I don't think that the Commission is inserting itself here. It is a concern that all member states sort of meet their obligations under the international human rights treaties and declarations, and of course, under international customary law around human rights obligations. So I wanted to ask the representatives of the civil society who have been given testimony here and witnessing and acting as witnesses of what is the state policy and state practice. Someone said, I don't remember exactly the name of the person who spoke about it, but you said that there's a responsibility of the international community, I think, to give oversight. So I think civil society organizations are articulating the responsibility of the Commission to give oversight on the question of compliance with human rights obligations. But my question to civil society organizations, in addition to international scrutiny, as is part of the mandate of the Commission, I want to ask, what has been the status of domestic oversight in relation to these policies, which you are saying are in violation of domestic human rights obligations as well as international human rights obligations. What is the status of domestic oversight? Who is undertaking that oversight? What are the institutions of oversight? And how have they been functioning? And then we heard, certainly in reference to the number of cases where the courts have made certain orders for the return or for around release from detention, or to prevent refoulement. And we've heard from civil society organizations the allegation that there's been non-compliance with court orders. And so my question related to non-compliance with court orders, what is your view, or what are your views on the implications of such non-compliance for rule of law? And also, what has been the judicial response to non-compliance by the executive around, if there has been non-compliance, what has been the response of the judiciary to that non-compliance? I am very concerned about the question of children, and what we have heard here today around detention of children in circumstances that are harsh and do not take into account the best interests of the children. And my question for the representatives of the state here today, how do the US authorities, I suppose, at federal level and at state level, ensure the protection of persons in vulnerable situations, such as children, who don't come on their own volition, they come with families, they come with adults. What is the protection for children, and also for other, I'm sure my colleague Commissioner Demise will speak about older persons, but so let me speak about children, because we've heard a lot about that today. What are the protections available to children, and how does the state respond to the allegation that children are being kept in detention facilities for long periods, overly long periods, and in poor conditions? And then, children in detention, are they provided with educational facilities and services, social care, counseling? How are children treated when they are in detention facilities? Thank you very much.
Muchas gracias, comisionada Clark. Voy a tomar la palabra ahora en mi carácter de relatora de movilidad humana de la Comisión Interamericana para completar con algunas preguntas concretas que tengo. La representante del Estado nos hizo saber que el acuerdo con El Salvador se encuentra disponible públicamente. Nosotros necesitamos, si es posible, acceder a ese acuerdo, así como saber si son públicos los acuerdos suscritos con otros estados en la materia. Estas eran algunas de las preguntas que habíamos hecho en nuestra solicitud de preguntas de información. Si esta solicitud nos la podrían responder, tal vez sería mucho más fácil recibir las respuestas por escrito. Nos parece muy importante acceder a las condiciones en las que se acuerdan la deportación de personas extranjeras a algunos países de América, como El Salvador, Venezuela, etc. Así que agradeceríamos acceder a esos acuerdos bilaterales. La segunda pregunta que tengo es, ¿cuántas personas fueron reconocidas refugiadas en Estados Unidos desde enero de este año hasta junio? O sea, en este semestre, ¿cuántos estatutos de refugio fueron concedidos por Estados Unidos en este primer semestre? Por supuesto, la Comisión Interamericana es absolutamente consciente de la facultad que tienen los estados para decidir, establecer sus políticas migratorias, y como dijo la comisionada Clark, estas políticas que son soberanas tienen que respetar los derechos humanos, y por eso las preguntas que tengo están vinculadas con esos compromisos internacionales de Estados Unidos. Entonces, ¿cuántos refugios fueron concedidos? Si hay un registro de personas detenidas por razones migratorias. Hemos escuchado denuncias de personas desaparecidas, que no se sabe dónde están. Son detenidas por facultades migratorias de Estados Unidos, por la policía, y luego no se sabe dónde están y dónde fueron, si fueron deportadas o no fueron deportadas. Hay un registro accesible de todas las personas detenidas por razones migratorias en Estados Unidos. Luego hemos escuchado algunos hechos de abusos cometidos en el marco de la detención de personas o vulneraciones, personas que tenían estatus legal y sin embargo fueron detenidas con riesgo de ser deportadas. Hemos escuchado algunas situaciones de abusos y la pregunta que tengo es, ¿hay funcionarios del Estado sancionados por estos abusos? ¿Hay investigaciones disciplinarias sobre policías que cometieron abusos o sobre funcionarios que cometieron abusos en el marco de sus facultades? ¿Cuáles son esas personas que están siendo investigadas o sancionadas? Hemos escuchado errores que se cometieron, personas que tenían estatus de refugio y que fueron de todas maneras expulsadas, personas que tenían residencia legal y sin embargo fueron detenidas. La pregunta es, ¿hay reparación frente a estos casos de errores, de abusos? ¿Se han otorgado reparaciones a estas personas que fueron detenidas, incluso violando la legislación de Estados Unidos? Esas son algunas de mis preguntas y por supuesto quedamos muy expectantes a recibir la respuesta por escrito a algunas de estas preguntas, pero también a las que hicimos en esa solicitud de información hace unos meses. Le paso la palabra al comisionado Vulcan.
Thank you, Madam Chair. And if you would permit me, just very briefly, I know we don't have a lot of time, but since we've been told that we should focus on petitions and cases, I just wanted to add very briefly to what you said, that these hearings represent an important part of our monitoring function, and that's under our statute. And the Commission, both in the past, in countries like Argentina and Peru, has been celebrated widely for its role, its monitoring role, these hearings and country visits. In the present, we are often praised for our work in Venezuela and Cuba. And so these hearings are not a violation of our rules or in any way anything unusual. And so I suppose it's just extending to the US the same equal treatment that we approach every country in the region. I just have, given the time, I just have a few very quick questions. Some of them are really silly, but I think it's partly my ignorance of what's going on right now in the US in the context of what we've heard about. I fully appreciate that all countries, all sovereign countries have the right to regulate their borders. And of course, crime and security are very important issues for every country, and they must address that. What I'm curious about is that our constitutional protections, things like due process and having the right to a hearing, having the right to a lawyer, are these things only for US citizens? I know where I come from, constitutional protections are for everyone in the territory. But is it different in the US? Are these things only for American citizens? The second thing is, again, in this context of removal of people who are threats, Tren de Agua, we've heard a lot about criminals. Are people who are seeking refugees status, asylees, are they criminals under US law? I'm just curious as to that as well. We've heard about, gay people who are hairdressers and others, people who have just tattoos, have no criminal association. Are they considered criminals under US law? And how does that promote national security? We've also heard testimonies, maybe not here, but generally that's been emerging about humanitarian abuses or violations of treatment while people are in custody. And this is not in El Salvador, this is in US detention centers. So we've heard about overcrowding, abuse of detainees, lack of health care, children separated from their parents. Is there any mechanism within the US about those practices? And finally, the one thing I'd like to ask civil society, based on your request, you said that there are even steps now of reprisals against lawyers who defend refugees or asylum seekers. And you talked about things like disqualification. I'm really puzzled about this. Is this within domestic laws, moving against American lawyers who are defending refugee or asylum? Is that within respect? Is that legal, basically? Thank you very much, Madam Chair.
Muchas gracias, comisionado Vulcan. Comisionada Gloria Monique Demis.
Thank you. Thank you very much, Madam Chair. I want to join my colleagues in greeting all present, civil society representatives, representatives of the state and the UN. I also underscored the statements that they made, and with respect to time, I will go straight into my questions. What criteria and evidentiary standards are being used to assess credible fear claims given by the expanded use of expedited removal? What protocols are in place to guarantee regular access to healthcare, legal representation, and family communication for detained migrants? What safeguards are enforced specifically for older persons and those with serious medical conditions during detention or removal? And if CSOs have data available or specific cases that they wish to share, please do so. Are there independent statistics on rates of abuse, medical neglect, and self-harm among detained migrants? And how are detainees, their families, and families kept informed of their transfer, processing status, and access to legal recourse if deported to unfamiliar third countries? These are my questions. Thank you very much.
Muchas gracias, comisionada. Le quiero pasar la palabra al relator de Derechos Económicos, Sociales, Culturales. Medio minuto, por favor, así puedo también administrar bien el tiempo.
Muchas gracias, Presidenta. Quiero agradecer a las organizaciones solicitantes y también al Estado. Voy a ser muy breve. Me gustaría tener más información sobre derecho a la salud con énfasis en salud mental. Es notorio que se trata de una afectación usual en los casos de condiciones de detención prolongada, aislamiento, incertidumbre jurídica y trato inadecuado. Hemos recibido información preocupante sobre el tema. Nos gustaría recibir más información que se ve en algunos casos comprometido en centros de detención. Estas preguntas son tanto para las organizaciones como para el Estado. Muchas gracias.
Muchas gracias, relator. Secretaria Ejecutiva, Tania Renaud.
Gracias, vicepresidenta, y muchas gracias a las organizaciones de la sociedad civil, a la ilustre representación de los Estados Unidos. Yo tengo dos comentarios. El primero es que hoy asistimos a esta audiencia que no es una novedad en el monitoreo. Tan solo en el informe anual de 2022, la Comisión Interamericana de Derechos Humanos ya se había referido a la preocupación por las detenciones que mostraban una estigmatización en algunos tipos de personas. En el 2023 se pronunció en su informe anual sobre el vencimiento del título 42. En el 2024 se pronunció en el informe anual sobre la solicitud de protección internacional y la disminución de los resultados en estas solicitudes y el aumento de detención de personas migrantes. En el 2024, la Comisión Interamericana también comentó en el informe anual la preocupación de que los Estados Unidos no tuvieran una institucionalidad específica para dedicarse a los derechos humanos y en la soberanía que le asiste a los estados de hacer sus políticas públicas. A mí me gustaría saber cómo se incorpora la perspectiva de los derechos humanos en la elaboración de la política migratoria. Gracias.
Muchas gracias. Le voy a pasar la palabra por 10 minutos, no más de 10 minutos, a las organizaciones para las respuestas.
Thank you very much. My name is Denise Slavin. I am with American Immigrants for Justice as a senior advisor. It is in times like these that our democratic institutions are faltering or even failing that we need the help of international human rights organizations. For example, the United States must comply with the U.S. federal court orders in JGG versus Trump case, seeking to redress due process violations of the over 200 men sent to CCOT. Asylum seekers whose lives are at risk in Venezuela should be given the right to return to the United States to be afforded these habeas rights. The Commission has asked a lot of very good questions with respect to the failures of the domestic government, and we can certainly submit some more information on this later in writing. But one of the things that the Trump administration has done has been eliminating the oversight offices that were previous existence on government functions. They've eliminated the Office for Civil Rights and Civil Liberties, CRCL, that used to oversee maritime introductions, various Department of Homeland Security operations. They've cut the staff in the Office of Citizenship and Immigration Services Ombudsman and the Office of Immigration Detention Ombudsman, basically taking away the rights for any individuals in detention or having problems with the system to file complaints against the system. And they have been targeting lawyers and civil society groups like us in the mix. Recently, there were 2 congressional hearings targeting non-governmental groups that were recorded and are available. They were outrageous accusations made against the abuse of federal taxpayer money by anybody who helped, quote, illegal aliens, unquote, which of course there is is an incredibly damning and shaming terminology, and there is no such definition for that word. The U.S. has basically said that they strongly support the Human Rights Commissions, and they think it is vital and would like to hear more petitions. However, they don't accept jurisdiction of this commission over petitions. So basically, they're trying to deflect to this domestic system that is broken. They don't submit to they haven't ratified the American Convention on Human Rights. So don't recognize their authority in this way. The presentation of the government today seemed to be a lot of smoke and mirrors and deflection. They basically tried to shift the blame for the human rights abuses occurring in CCOT to El Salvador. El Salvador has basically said that the people held there were under U.S. jurisdiction, and that that the U.S. is responsible for those concerns and problems. So there has been a lot of smoke and mirrors basically going on. I did not hear a strong suggestion that there weren't abuses and tortures occurring in El Salvador. I would like to present shortly some of our requests for engagement of the Commission. We really appreciate the engagement today. We heard a lot of things from the U.S. government today that we have never heard before. But we would like to encourage this engagement to continue in the forms of both engaging with the community in the United States, conducting site visits in the areas of extreme concern, the continued or increased use of thematic hearings, and publishing reports about human rights violations uncovered. We can go into more detail of these later. I'm wondering if some of my colleagues, I would like to talk a little bit more about the detention conditions that we have experienced in the United States. These conditions have been cruel and incredibly cruel and inhumane. But the biggest thing I have to say is that 14 immigrants have died in DHS custody since October, and they deserve to be remembered as people and not just a number. They came to the United States from Cuba, Canada, Mexico, Haiti, Vietnam, Colombia, Ukraine, Ethiopia, Honduras, Guyana, and India. They are Tien Yu Fan, age 55, Isidro Perez, age 75, Johnny Noviella, age 49, Jesus Molino Vea, age 45, Abelardo Evaneda Delgado, age 68, Marie Ann Blez, age 48, Neop Nuwan, age 55, Brian Rayan Garzon, age 27, Maxime Cherniak, age 44, Sarawit Gezahain Dijene, age 45, Jenry Ruiz Gien, age 29, Ramesh Ameshed, age 60, Prajek Karen Singh Katara, age 60, Jose Manuel Sanchez Castro, age 36. Action is needed to remedy these detention conditions and prevent further deaths, the latest of which occurred just 2 days ago, July 22nd, in the Carnes facility. We will detail more our request for engagement, site visits, hearings, and reports later. But I wanted to see if any of my colleagues wanted to comment, particularly on detention conditions or the conditions for children.
Yannick.
No, please, just in consideration of time, I would state that civil society has had a hard time receiving information from the government around the conditions of detention due to insistent prohibition of not just lawyers gaining access to detention, but civil society and elected officials alike, which has been documented in various cities and states across the country. Outside of that, Taylor, please, anything you would like to share?
I was just going to mention that I would be happy to respond to some of the questions on detention of children, but I can do so in writing in the interest of time, as I know our colleagues have some more to share.
I think we're going to share a recording now from one of the people who was removed to a third country after seeking asylum at the border. So I'm just going to share my screen so we can share an audio testimony.
Բարև ձեզ, ես և իմ երկու անչափահաս որդիների հետ փախչեցինք մեր երկրից, քանի որ մեզ հետապնդում էին և սպառնում էին։ Հունվարի 22-ին ես մուտք գործեցի Միացյալ Նահանգներ և քաղաքական ապաստան խնդրեցի նրանցից։ Նրանք շատ մեծ դժվարությամբ մեզ ներս տարան և սկսեցին մեր գրանցումը։ Նրանք մեզ տարան սենյակներ, որտեղ կային բազմաթիվ մարդիկ։ Ինձ և 8 տարեկան երեխային տարան այլ սենյակ, իսկ իմ 12 տարեկան որդուն առանձնացրին այլ սենյակ, որտեղ կային տարբեր ազգերի տղաներ։ Մենք շատ մեծ վախի և սարսափի մեջ էինք, քանի որ իմ որդին ընդամենը 12 տարեկան էր և նա երբեք չէր եղել նման վայրում, առանց իր ծնողի։ Նրա հետ ես հանդիպում էի միայն ճաշի ժամերին։ Նա շատ վախեցած էր, նա չէր խոսում։ Հարց էի տալիս, սկսում էր լացել։ Նա խնդրում էր, որ մենք այդտեղից դուրս գանք։ 29 օր մենք մնացինք այնտեղ։ Երեխաները նորմալ չէին սնվում, սենյակները սարսափելի ցուրտ էր։ Ես նրանց խնդրում էի, աղաչում էի, որ ինձ ինչ-որ մի լուր տան, բայց նրանք ոչինչ չէին պատասխանում։ Ոչ հարցազրույց, ոչ դատ, ոչ մի բան տեղի չունեցավ։ 29 օր հետո մեզ տեղափոխեցին այլ վայր, Սան Դիեգո։ 3 ժամ մնացինք այնտեղ, բայց թվում էր դարեր, քանի որ շատ վախենալու և սարսափելի տեղ էր։ Ոստիկանները զենքերով գորում էին մարդկանց վրա, շատ կոպիտ էին մեզ հետ վարվում։ Նրանք մեզ տարան օդանավակայան և հետին մուտքով մոտեցին ինքնաթիռ։ Ոչինչ չասելով, ոչ մի ստորագրություն չվերցնելով, ոչ մի տեղեկություն չհայտնելով, մեզ տեղափոխեցին Կոստա Ռիկա։ Արդեն 5 ամիս է մենք այստեղ ենք։ Այստեղ շատ շոկ է։ Երեխաները բազմաթիվ մաշկային հիվանդություններ են ստանում։ Սառը ջրով են լողանում։ Ես ընդամենը ուզում էի իրենցից ապաստան խնդրեի, քանի որ նաև ամուսինս այնտեղ է 4 տարի եւ սպասում է իր դատին։
Perdón,
Ես խնդրում եմ
el tiempo ha terminado. Les pedimos que nos envíen ese video a la comisión y le voy a pasar la palabra al ilustre Estado de Estados Unidos por 10 minutos.
Hello, my name is Sarah Hunter. I'm with the Office of the Legal Advisor here at the State Department. Given the request of the hearing request today and its breadth, I know I have limited time, so I'm going to try my best to hit as many of these questions as were asked. First, Commissioner Clark, I'll have to get back to you about specific information about children in detention. I will say that it is a last resort that DHS uses. As you know, as you visited one detention center last year, we have robust protections available through our national detention centers and performance-based national detention centers standards. Those are periodically available, updated and available online, as well as data related to those who are detained, very easily accessible on DHS's website, Department of Homeland Security. And, you know, I want to note, we are trying to be transparent about these things, hence why there was that visit last year where you were given unprecedented access to facilities and detainees who wanted to discuss matters with you all. Commissioner Polchak, appreciate you recognizing that some of the questions you're asking about specific numbers are not going to be answerable right now, but I will take those questions back. On your question about agreements, I was a little bit unclear as to specifically what you were asking about, but so I'll kind of put those in two buckets. So as we said, or as my colleague Lily said, we're taking this to be the response to the Article 18 request that said, with regard to the 9 bonding arrangements with El Salvador, regarding the transfer of the individuals we discussed, all of those are available on the State Department's website, very easily accessible. If you Google CASE Act reporting, CASE Act is C-A-S-E, and go to the non-binding instruments page, can all be downloaded pretty quickly. Let me just look at my notes here. Oh, your question about disciplined and investigated individuals for alleged abuses. I would just note that we have robust civil rights protections for individuals, including those in detention, and those mechanisms do allow for the possibility of relief in the form of monetary settlements and other mechanisms, such as injunctions against further issues. Commissioner Volkan, couple different things to you. Just to clarify, we're not saying that thematic hearings violate the rules or not useful, because we do see the use of them. We just disagree a bit with the commission on the prioritization when it comes to selecting which matters are heard, given the huge backlog. To your question about constitutional protections, I don't want to be a lawyer about it, but it does depend. With regard to due process, it depends in part whether we're talking criminal charges or immigration charges, and there is some variation there depending on whether you're a citizen or otherwise, depending on your status, depending on what particular protections we're talking about. Commissioner Demise, specific provisions on health for older persons. Off the top of my head, I can't provide specifics on older persons, but to reiterate about the detention standards that ICE is bound by, as well as the performance-based national detention standards for contractors, do provide access to health services mandated within set periods of time. We believe those protections are very much in line with our obligations under both our domestic law and international law. Okay, so the question about, there was a question that mentioned the social rights. And I just want to reiterate, you know, as you all know, we are parties to the ICCPR, but not to the International Covenant on Economic and Social Rights, though we are signatories. But as I just stated, we have various internal processes to ensure that individuals receive adequate treatment while in our custody. Notwithstanding that. I think there was another question about human rights protection in the US. That's extremely varied depending on what exactly we're talking about. But again, referring to our status as having ratified the ICCPR, I would note that we very much consider our Bill of Rights in line with the protections provided in the ICCPR. Finally, I want to note a couple of one more point about commitments. There was, sorry to go back to Commissioner Pochak's question about arrangements. As I said, the Case Act website doesn't have our arrangements with El Salvador. But if you're asking about between El Salvador and the Maduro regime, that agreement, that was a series of commitments made separately by El Salvador and representatives of the Maduro regime and communicated to the other side through US intermediaries. It's not a single instrument, and as far as I understand, it's not otherwise written down, and the US is not a party, so that's not something we can provide at this time. Finally, as we said earlier, we just want to reiterate that we are ensuring maximum compliance regarding the 252 Venezuelans. We obtained assurances that if somebody is required to return by court order and wishes to return, that Maduro will not impede it. And we generally are doing what we can to make sure that we are complying fully with court orders. So I just wanted to state that. With that, any other questions I'll have to take back, but we appreciate everybody here today. Thank you.
Muchas gracias. Thank you very much. Agradecemos mucho la participación de las organizaciones, a quien le reiteramos nuestra solidaridad y nuestro apoyo por el trabajo que están haciendo en defensa de las personas migrantes y solicitantes de refugio. Y le agradecemos también a la representación de Estados Unidos por este esfuerzo que han hecho en responder las preguntas, tantas preguntas, y esperamos que nos puedan proporcionar toda la información por escrito con la consulta a las distintas agencias involucradas. Estas audiencias son oportunidades para visibilizar situaciones, para generar diálogos constructivos entre organizaciones, entre defensores y defensoras de derechos humanos y funcionarios del Estado. Ojalá que este espacio se pueda replicar en Estados Unidos, entre las autoridades de Estados Unidos y las organizaciones que tienen legítimas preocupaciones en esta materia. Nosotros desde la Comisión Interamericana bregamos por la defensa de los derechos humanos de todas y todos. Y sepan que advertimos que Estados Unidos ha sido históricamente un refugio para muchas personas perseguidas en muchos países de la región y fuera de la región, ¿no? Y este es el lugar que necesitamos internacional y regionalmente seguir manteniendo, un refugio para las personas que están siendo expulsadas, hostigadas, violentadas. Por supuesto, Estados Unidos tiene soberanía sobre su política migratoria, pero también hay muchas necesidades internacionales y regionales que están en juego, y ojalá que Estados Unidos sea coherente con lo que declama también de advertir situaciones institucionales, políticas en muchos países de la región, como Venezuela, como Haití, como Nicaragua, como Cuba, y que pueda ser coherente en su política de refugio y de migración al respecto. Cierro entonces, paro la grabación y le voy a pedir a mis colegas de la